Good day, Crime Talk aficionados. We have a great show for you today. First, the alternate suspect defense in the Bryan Kohberger matter. Why are they trying it? Next, we have a tragic shooting at the Capitol Jewish Museum, and it claims the lives of a young diplomatic couple. A disgusting display of cruelty. Some teens bully and attack a disabled woman in Hawaii. We have this day in legal history, the quote of the day, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And remember, you can check us out anytime on any of your favorite podcasting apps. Now, before we get to the docket today, let's remember to go to crimetalksearch.com and sign up for that background subscription service today. When you sign up, you can do as many searches as you desire. And remember, you can cancel anytime. So whether you want to keep it and do hundreds of searches in a month or want to do one and done, you can do that. But you are going to get a report literally prepared while you wait, and it's emailed to you, and you can get updates. And here's the beautiful thing. If there's someone you want to check out, maybe you think there's something a little fishy with a partner or a spouse going on, right? Go to crimetalksearch.com, put in their name. You're going to get a list of all phone numbers associated with that particular person, right? And if you have multiple phone numbers, does that person have some burner phones with them, right? You're going to get their social media presence. You're going to find out what sites they're logged into. You're going to get their email addresses. And you say, well, that's funny. My spouse only has one email address that I'm aware of, or maybe two for work and a personal one. But why does he have all these other email addresses? Could that be because he's signing up for all those dating sites? Yes, ladies and gentlemen, go find out. If people aren't telling you something, you need to go find out for yourself. You're also going to find out if somebody has criminal history. Are they married? Are they divorced? Do they have liens or judgments? Go to crimetalksearch.com. You're going to be happy that you did. All right, let's go ahead and get to the docket today. Now we're heading into the Memorial Day weekend. Most courts are done. For example, Karen Reed, no court today. P. Diddy case, no court today. And so pretty quiet day, but things are going to pick up next week indeed. But let's talk about a couple of things. The alternate suspect defense in the Bryan Kohberger matter. All right. Why are they doing it? Well, we explained last Friday, and we'll put the link down below, where I explained the legal standard for the alternate suspect. Now, personally, from what I know, but I don't know everything in the case, so we're going to have to wait and see. But what I know right now is there's not enough for the defense to present an alternate suspect theory in the trial. Based upon what we know right now, my opinion will change. Like I've always said, any good attorney, your advice changes based upon new facts that come around. Happens all the time. You do it in your own personal life. You cannot be so focused and tunnel visioned to ignore new evidence and new facts. If you do that, your client's going to prison for a long, long time. But in this particular case, it's going to be very difficult because basically the defense has to convince the judge that basically there's probable cause to arrest somebody else for the crime that Bryan Kohberger has been charged with. That is going to be a very, very tough road to get to, a very big hurdle to leap over for the defense. Now, obviously, we do not know what was filed as it relates to the facts that the defense is trying to get in as an alternate suspect. We know it probably has something to do with the glove and the DNA that was found from some blood at the house, but there's nothing to indicate because the legal standard is you have to be able to show that somebody was actually there at the time of the murders and that they participated in that. So short of a confession, it would be very difficult to do. We'll leave it there. Okay. Now, we also know in the motion to continue, the 40-page motion to continue, that I went back and reread this again. It's a lot of boilerplate motion to discontinue type of argument. Judge, there's so much work. We can't do it. We're not going to be effective. They're going to constitutionalize that argument by saying, I won't be effective, Judge. And you don't want this case to come back on ineffective assistance of counsel. And I said yesterday, I would say 51-49 chance that it gets continued because the judge needs to make sure that the defense is prepared. But I think the judge, based upon everything that's taken place, could actually now find that the defense has provided effective representation, And based upon, for example, like their alternate suspect theory, that no, there's no need for a further continuance. That would be some basis for it. As it relates to all of the reasons for the continuance, that they haven't done enough work, they're still doing this family history. We need to go back 3 generations to try to figure out something's there. If I was the judge, I'd be saying basically what Judge Hippler said at the hearing. What have you been doing for the last 2.5 years? I mean, the prosecution only had an 8-week head start from the time that Kohberger allegedly committed the crimes to the point where he was arrested. So you've been getting basically everything in real time. It's not like a situation where, the case was investigated for years, the prosecution files, and they say, well, let's go to trial in 6 months. Like, Judge, they've had years. I've had 6 months. I need a little more time. Okay. But in this particular case, it's not that complicated of a case. It really is not, ladies and gentlemen. Trust me, I've done lots of homicides. Homicides are sometimes often the most simplest cases that you have to deal with, but you get a little more due process just because the consequences are so great. Obviously, most cases, it's a life without the possibility of parole result. Here, a potential death penalty. So the judge has a look at that, but I think the judge could make an appropriate record and say, no alternate suspect is coming in. This isn't that complicated. You can tell his life history, right? I get a life history in the first couple of visits on a serious case. What's going on? Where'd you grow up? Tell me how you got here. Go talk to family members, get records, hire a social worker to go acquire all that stuff. This is death penalty litigation that they should have been doing for the last 2.5 years. I think this was a Hail Mary attempt. This motion to continue was a Hail Mary attempt to get a continuance because they don't want to go to trial because they've got nothing. Okay. They know that it's ugly. And I'm not saying this because I am anti-Bryan Kohberger. I want him to get a fair trial, like everybody should want him to get a fair trial. That's our system of justice. And so we want him to get this fair trial, but it doesn't mean it gets delayed forever. Like I said, I've done this for 30 years, ladies and gentlemen. I filed, sometimes there's cases you just don't want to go. When they ask when you want to reset it, I'm like, I don't know, 2045 would be good, right? Because all the witnesses would be gone. It's a joke and everybody gets it. But I don't say that on the record or anything like that, but it's a bad case. There's no good facts. The only thing that we have is a continuance because nothing bad will happen if we don't ever go to trial. Okay. Maybe we'll be able to work out a disposition. That's what the defense is trying to do here. You have competent counsel. They've worked this case. They would know if there were issues. They know what they had and what they didn't have. They filed their motions. They gave it their best shot. Now it's time to go try this case. So I hope that Judge Hippler will deny that. But let's get back to the alternate defense theory. I don't think it's going to work. The standard is they have to prove that somebody else committed the crime. And frankly, why would you wait all this time? It's kind of like if your alibi is so good, why are you going to wait 2.5 years in custody? No, you're going to say, this is my alibi. Look, it proves that I'm not there. All right. The reason why they're doing it is because they're throwing it out there, literally spaghetti against the wall kind of thing, see what sticks, because it's worked before. All right. Now, obviously, the case against, Kohberger for the 4 Idaho students, the defense has suggested this alternate perpetrator during the hearing back in May of this year. And the Judge Hippler, keeping things procedural, asked for more evidence to support this claim. Now the strategy is really less about actually pinpointing, the one-armed man, the shadowy figure, and more about trying to sow some doubt in the eyes of the jury. Basically, it's like saying, sure, my client was there, but what about the guy in the hoodie, right? Or what about the guy with the glove that's missing? That's what they're trying to raise. But you can try to do that. Sometimes it works, sometimes it doesn't. For example, let's go little stroll through history here. First, you got the O.J. Simpson and the Colombian cartel allegations, right? O.J. Simpson's 1995 trial for the murder of Nicole Brown Simpson and Ronald Goldman was a circus, no doubt. And his defense team, led by Johnny Cochran, created that circus. They spun a tale of a Colombian drug lord targeting Faye Resnick, a friend of Nicole, over alleged drug debts. Apparently, Nicole and Ronald Goldman were just collateral damage in this narco drama. The jury bought enough doubt to acquit Simpson, who later vowed to hunt and find the real killer. perhaps while checking at every golf course in the state of Florida. And that alternate suspect theory was less evidence-based and more like a script pitched to a Hollywood producer. Then we got Scott Peterson and the burglary bandits, right? Scott Peterson, convicted in 2004 for the murder of his wife, Lacey, and their unborn son, Connor, had his defense attorney, Mark Garagos, point to a burglary near their Modesto home as a possible link to Lacey's death. It was a classic blame the neighbor move, suggesting thieves might have actually escalated from stealing to murder. The jury wasn't convinced, and Peterson got life ultimately without parole, even though he was originally sentenced to death. Fast forward to 2025, and the Los Angeles Innocent Project is waiving new witness statements about the woman resembling Lacey walking her dog, hoping to revive that somebody else is the real killer. It's a long shot, but you got to admire their persistence. Don't forget Casey Anthony and the poolside tragedy of her daughter, right? Casey Anthony's 2011 trial for the death of her daughter, Kaylee, featured a defense that could have been, well, a movie, for goodness sakes. Jose Baez claimed Kaylee accidentally drowned in the family pool, and it was Casey's father, George, covering it up while allegedly abusing Casey. The father denied those allegations rather vigorously of a man being accused on national TV of doing inappropriate things with a child. Now, the jury acquitted Casey of murder, but dinged her for lying to police, proving you can't always sell a drowning story with a side of the family dysfunction. The alternate perpetrator here was more tragic accident than the mystery killer who actually really did it. And then going way back, the Sam Shepard and the bushy-haired bandit case. That's right, Dr. Sam Shepard, accused of murdering his wife Marilyn back in 1954, insisted a bushy-haired man was the culprit. And after a 4th of July party, Shepard claimed they'd returned from the beach walk to find Marilyn chopped up and chased the intruder to no avail. Sounds like a movie plot, right? And then in 1966, his conviction was overturned, proving that the bushy-haired man defense had legs, albeit shaky indeed. And that inspired the TV show The Fugitive, so at least it left a little pop culture legacy as well. Then we have the Jeffrey McDonald and the hippie hit squad. Now, McDonald was convicted back in 1979 for the 1970 murders of his pregnant wife and his 2 daughters at Fort Bragg, and he blamed a gang of hippies led by a woman in a floppy hat chanting, "Acid is groovy, kill the pigs." It's the kind of story you'd hear at a Grateful Dead concert gone wrong. Now, despite McDonald's stab wounds, the jury didn't buy the Manson family knockoff theory, sentencing him to life in prison. The alternate suspect tale leaned hard into the era's counterculture panic, but couldn't sway the jury in that one. So ultimately, the alternate suspect defense is the legal equivalent of throwing, like I said, spaghetti at the wall to see what sticks. Sometimes it creates enough doubt to win freedom, as in the Simpson and Anthony cases. Other times, well, it crashes and burns. For Kohberger, the success of this strategy hinges on evidence or the lack thereof. And in the courtroom, it's not always about proving someone else did it. It's about convincing the jury that maybe somebody else did it. Is that going to be enough? We'll all find out together, ladies and gentlemen. Next, a tragic shooting at the Capitol Jewish Museum claims the lives of a young diplomatic couple. That's right. A devastating shooting outside of the Capitol Jewish Museum on Wednesday evening, May 21st, claimed the lives of Yaron Leshinsky, an Israeli citizen, and Sarah Lynn Milgram, an American citizen. Now, the young couple, described as being on the verge of engagement. Apparently, the big proposal was going to come this weekend, if you can imagine that. Anyway, the couple was gunned down as they left a young diplomat's event at the museum. Now, the suspected shooter is Elias Rodriguez. He's a 31-year-old man, and he was arrested shortly after the incident and now faces multiple murder charges, including the murder with the possibility of the death penalty. Now, according to the affidavit written by the FBI, surveillance footage captured the chilling details of the attack. Rodriguez, who had purchased a ticket to the event just 3 hours prior, approached the couple as they prepared to cross the street. According to the arrest affidavit, Rodriguez walked past Leshinsky and Milgram, turned to face their backs, and drew a firearm from his waistband. Extending both arms, he fired multiple shots as evidenced by muzzle flashes, and after the couple fell to the ground, Rodriguez advanced closer officer leaned over them and continued firing. The affidavit notes that Milgram, referred to as Decedent One, attempted to crawl away. Rodriguez followed her and fired again. He appeared to reload his weapon before shooting Milgram several more times. In total, he fired 21 shots, ladies and gentlemen. Now, Mr. Rodriguez, a Chicago resident, had flown to Washington, D.C. on May 20th, 2025, with a firearm in his checked baggage, which he had legally declared with the airlines. After the shooting, he had been seen on video jogging back towards the museum entrance, where he discarded his weapon and, after it stopped shooting and firing, obviously, mistakenly assumed to be a victim, Rodriguez was allowed inside the museum by security guards. There, he reportedly told police, "I did it for Palestine. I did it for Gaza. I'm unarmed." Following his arrest, Rodriguez waived his Miranda rights and expressed admiration for Aaron Bushnell, who set himself on fire in front of the Israeli embassy in 2024, calling him a courageous and a martyr. The event at the Capitol Jewish Museum was a private gathering for young Jewish professionals aged 22 to 45, with the location undisclosed publicly due to security concerns. Attendees were required to purchase tickets to access the venue's address, and the shooting has sent obviously shockwaves through that community, with protesters gathering outside the museum and investigators remaining on the scene into Thursday to process evidence. Now, Rodriguez, who appeared in federal court in Washington, D.C. on Thursday, faces 5 charges: murder of foreign officials, causing death through firearm discharge, discharge of a firearm during a crime of violence, and 2 counts of first-degree murder. The judge informed Mr. Rodriguez that convictions on the first 2 charges could result in the death penalty, and while the other charges carry potential life sentences as well. Now, during the hearing, Rodriguez, dressed in a white prison jumpsuit and unrestrained by handcuffs, remained calm, nodding as the charges were read and briefly smiling as the matters were set for future proceedings. Now, Rodriguez is being described as a far-left activist, previously worked for an oral history research for the History Makers, a nonprofit focused on African-American communities. His work profile has since been removed from the organization's website, described his role as a preparing research outlines and biographies accomplished African-American leaders. Rodriguez was also affiliated with the Party for the Socialism and Liberation, the PSL, though the group issued a statement denying involvement in the shooting, saying Elias Rodriguez is not a member of the PSL. "We have nothing to do with this shooting and do not support it." Well, guess what? They also found an alleged manifesto attributed to Rodriguez, published online before the attack, criticizing the U.S. government's stance on Israel and claiming public opinion has shifted against the genocidal apartheid state. Surveillance footage also reportedly captured Rodriguez shouting "Free Palestine" after the shooting, and while some pro-Palestinian demonstrators have praised Rodriguez, calling him a hero, the broader community has condemned the violence. So obviously, what we have here, ladies and gentlemen, is a man goes to a location, basically shoots 2 people in the back, repeatedly fires some 21 times. Obviously, these people are now dead. Horrendous acts. People condemn them, right? If that's not murder after deliberation, I don't know what is. But then let's go back to the Luigi Mangione case, right? Man accused of killing the CEO in the back, firing, several shots, killing him, and then fleeing the scene, trying to mix in with the crowd. He's seen as a hero. I don't know. Sometimes you have to be intellectually honest when you evaluate the law, right? Here's the law. Here's the facts. It's not like you're rooting for a sports team, ladies and gentlemen. You have to be intellectually honest. And if the facts are nearly identical and it's being condemned, and then the other case, like the Mangione case, he's being praised as a hero and people are funding his defense with almost $1 million, you got to wonder what's going wrong. Now, this Rodriguez guy, he's screwed. The people that he was out there, acting on their behalf, trying to raise awareness, I wonder what kind of legal defense fund he's going to get raised for him. My guess is it's probably going to be 0, ladies and gentlemen. Something to think about. Something to think about as you go into this long weekend. Am I being intellectually honest? Think about that. That's what the law requires. Calling balls and strikes. And if you always get the result that you want, you're not being intellectually honest. I assure you. But as a defense attorney, You have to be intellectually honest, because if you give the bad advice because you ignore the bad facts and your client goes to prison for longer than he should have because you didn't say this is a bad fact, well, you could be potentially committing malpractice now, couldn't you? Next, a disgusting display of cruelty. Teen bullies and attacks a disabled woman in Hawaii. So the reprehensible action of a group of teenage bullies in Hawaii has sparked outrage after they were filmed mercilessly assaulting a defenseless 21-year-old disabled woman. The vile behavior of these four adolescents aged 13, 14, 16, and 18 reveals a shocking disregard for human decency as they surrounded and viciously attacked their vulnerable victim, identified only as Carly, who cowered in fear, unable to defend herself against the barrage of kicks and punches to her head. Now, this despicable act, which occurred in April, was brazenly recorded and later posted online, exposing the cruelty of these so-called youths to the world. The footage shows Carly clearly confused and helpless, enduring the onslaught without retaliation, while the attackers took turns inflicting pain in a display that a local spokesperson condemns as evil. The sheer cowardness of targeting someone so defenseless is nothing short of abhorrent. Now, the community there, rightfully incensed by the atrocity, refused to stand by. In a powerful response, residents took matters into their own hands, live streaming their pursuit of the perpetrators with up to 11,000 people watching as they marched to the homes where these deplorable teens were later found. Footage captured the community's resolve, with dozens of students and parents confronting the suspects, some even scaling buildings to demand accountability. Such action underscores the depth of the disgust felt by those who witnessed the brutality and inflicted upon Carly. Now, the eldest of the group, an 18-year-old, Jaslyn Keola, had the audacity to offer a flimsy excuse upon her release from jail, claiming that she was pressured into the attack and didn't want to fight. Well, her apology, dripping with insincerity, had been met with justified scorn by locals who see through her attempt to paint herself as the victim. The lack of genuine remorse from Keola and her cohorts only compounds the repugnance of their actions. While charges against the teens have been temporarily dismissed, police are gathering evidence to pursue a stronger charge. Hopefully it will come soon. Now, the mother of two of the perpetrators issued an apology, but her words also rang hollow in the face of such a heinous act, claiming she didn't mean for it to go this far, does little to absolve the responsibility of raising children capable of such cruelty. These students at a high school have brought shame not only to themselves, but to their institutions, which are now cooperating with the authorities. Now, Carly's family, somewhat blindsided by the video that had their daughter never been disclosed, expressed gratitude for the community support while pleading for privacy and urging against retaliation. Their dignified response, obviously, is a stark contrast to the depravity of the attackers. You know, ladies and gentlemen, I don't know. You go online and you see these fights and everything put on, and people attacking people, cold cocking people, not expecting it. I mean, these people are just cowards. And I hate to say it, as a member of the community, these people need to go to prison. This is a crime of violence, okay? And people that commit crimes of violence when they're young, the studies will show the only way they stop committing crimes of violence is they have to get too old where they can't commit the crimes of violence. So they need to be locked up. They're not one guy to say, oh, I'm really sorry, I'll never do that again. Recidivism studies will show that if you commit a crime of violence when you're younger, it will happen yet again in the future. That's why on crimes of violence, they're not just doing it to be mean and cruel. They're doing it because that's what the evidence shows. We have to lock you up, that you get to the point where you're too old to harm anybody. And these kids, disgusting, 13 years old. Somebody told them that that was okay. I don't know, maybe this is one of those cases we should possibly charge the parents, right? One of those unique theories. Crumley case, perhaps. Charge them all. This is what I said. You start going after that, maybe this is actually the case where it's truly deserved. Bad parents, let's charge them all. Next on the docket, this day in legal history. Let's go back to 1498, ladies and gentlemen. Yes, a radical Dominican friar by the name of Girolamo Savonarola was burned at the stake in the Republic of Florence on May 23rd, 1498, for preaching against the practices of the powerful within the Catholic Church, including the then Pope Alexander VI. And he also did the horrible crime of celebrating Mass while being excommunicated. Let's go back to 1701. Captain Kidd, hanged for piracy. That's right. Captain William Kidd, convicted of piracy and murder, was hanged in London, and his body was later tarred and hung up in a gibbet, an iron cage at the mouth of the River Thames, as a warning to others. Then jumping ahead to this day in 1914, the Department of Justice was prosecuting high-profile cases under the Mann Act, targeting interstate human trafficking. These cases obviously expanded federal jurisdiction over moral crimes. On this date in 1934, Bonnie and Clyde killed in a police ambush. That's right, the notorious outlaws Bonnie and Parker and Clyde Barrow were ambushed and killed by Texas and Louisiana State Police near Sales, Louisiana. On this date in 1966, the Supreme Court decision in Mills v. Alabama ruled that state law prohibiting Election Day editorials violated the First Amendment. The decision reinforced the protection of freedom of the press in the context of elections. And on this day, in May 23rd, 1977, the Department of Justice was concluding Watergate-related prosecutions with the conviction of former President Nixon's aides. The scandal spurred campaign finance and government ethics reforms, but not enough. Anyway, on this date in May 23rd, 1788, jumping back a few years, South Carolina ratified the United States Constitution, becoming the 8th American state. Next, the legal quote of the day. It is better that 10 guilty persons escape than that one innocent suffer. Written by Sir William Blackstone in 1765. The quote underscores the principle that the legal system prioritizes protecting the innocent, even at the risk of acquitting the guilty, emphasizing the importance of reasonable doubt in ensuring justice. And then finally, our dumb criminal of the day. Our featured dumb criminal today is Darren Dykes, the spicy swigger. Once upon a sizzling Florida afternoon, our protagonist, Darren Dykes, a 36-year-old connoisseur of poor decisions, decided to spice up his parole restrictions life with the infamous hot chip challenge. For those unfamiliar, the fiery fad involves munching on a tortilla chip dusted with a chili spices so potent that they could make a dragon weep, clocking in at the upper echelons of the Scoville scale. But Darren, a seasoned felon with a rap sheet longer than a CVS receipt, wasn't content with merely tempting his taste buds. He went for a full-blown parole violation spectacular. Picture this. Darren, already a decorated veteran of Colorado's felony stalking scene, was lounging in the Sunshine State with his parole terms were clear as a summer day. No alcohol, no bars, and oh yes, always carry that pesky tracking device. But Darren, with the wisdom of a man who's juggled convictions for cocaine sales, heroin possession, grand theft, and even violating a domestic violence protection order, he had other plans. So in late March, he stared in his own social media blockbuster, boldly clutching a Corona while wrestling with the volcanic fury of that devilish chip. As the chip set his mouth ablaze, Darren, in a move that screams genius, took a swig of beer to douse the flames. A swig! Because nothing says I'm sticking to my parole like a refreshing gulp of a forbidden brew. Of course, it was captured on video for all to see, and the probation officers, even the vigilant critics of Darren's life choices, stumbled upon the cinematic gem, likely while scrolling through his social media, a treasure trove of questionable content. When confronted, though, Darren didn't deny it. The chip was so hot, he confessed, that the Scoville scale were a valid legal defense. But wait, there's more. Earlier in the month, Darren also earned a demerit for ditching his tracking device, proving that if you're going to violate parole, you might as well go big. With a criminal resume boasting 7 years in state prison and a parole termination date not until 2026. Darren's late summer stunt landed him back in the slammer yesterday after a not-so-friendly chat with the probation officers. Anyway, the affidavit was blunt. Darren is a risk to himself and others with any further alcohol use. Translation: our Spicy Squares encore performance was a flop. So here's to Darren Dykes, our featured dumb criminal of the day, who took a tortilla chip challenge and turned it into a masterclass in how not to stay out of jail. Stay cool, Darren, or at least stay away from the coronas. All right, ladies and gentlemen, that's all we have for you today. Hope you enjoyed the show. Enjoy your long 3-day weekend, Memorial Day. We'll see you Monday, but always remember and never forget, the Constitution matters.